The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases will be submitted this afternoon. Fagen versus Iddings, Iowa Supreme Court Attorney Disciplinary Board versus Blessman, and State versus Gaskins. We'll now hear the arguments in the first case, Fagens versus Iddings. Ms. Conlin.
Thank you, Your Honor. May it please the Court. The issue presented for the Court's review is under what circumstances does a plaintiff waive the physician-patient privilege when pleading generic causes of action for mental distress, mental anguish, mental disability, emotional distress, and the like. Let me start by telling you a little bit about the facts of this case. Cameron Fagen was an 18-year-old student at Grandview University. He lived in a dorm. He was a bowler, an athlete, and he lived in the dorm with football players and basketball players. And one evening, they began horseplay that involved rolling Cameron up in a discarded piece of carpet, setting him up in the corner, hitting him, punching him, kicking him, beating him with a stick, and pouring cereal on his head. We don't have to guess about what happened here. It's all on tape. It lasted 39 minutes, and those who have seen the tape agree that it is a really bad thing. We pled in that case that the plaintiff has endured and will endure great physical and mental pain, physical and mental disability, and loss of enjoyment of life. The defendant seeks to compel Cameron to disclose all of his medical records from birth until the present time. In those medical records, in the 4th through the 6th grade, he had some psychological treatment for anger issues. We say we are not going to give you those records. They have nothing whatsoever to do with the mental anguish that any ordinary person would suffer from being rolled up in a carpet, hit with a stick, and having cereal poured on your head. The case that we think most aligns with this case, though this court has never dealt with this issue, Chung. In the Chung case, the plaintiff says that the defendant was drunk and caused the collision and therefore sought Chung's records, BAC records as I understand it. And the court said a very prescient thing, and it was, there are very few cases in which a creative attorney cannot figure out some way to make mental health records or health records generally an element of the claim or defense. And if that happens, there would be very little left of the privilege. Jaffe is the United States Supreme Court case that deals with this issue, and it established a federal psychotherapist privilege, but it also held a couple of other things that may be important for the court's determination. It held that there will be no balancing test in the cases involving psychotherapist privilege in civil cases. It also held that there needs to be certainty. When someone goes to a psychotherapist, they need to be sure that all of the things that they say to that psychotherapist will not be disclosed at any time to anyone. The Jaffe case did not deal with waiver. That's where we are today. The party claiming the patient-physician privilege obviously has the burden of showing that it exists. There is no question here that the privilege itself exists. These are mental health records. And then the party seeking the records or the testimony has the burden of proof of demonstrating that the plaintiff has waived the physician-patient privilege in this context.
Could I ask you just sort of a question? I understand you're not intending to call a mental health professional at trial. Could you kind of walk me through what testimony you do intend to present at trial in support of the emotional distress, mental anguish part of your damages?
We're not quite there yet, Your Honor, but my expectation would be that I would ask Cameron to talk about what happened, how it made him feel, and the like. I may ask his parents. he called his parents that night, and I think he drove home that night, in the middle of the night. And so I might ask his parents what they could observe about his condition of mental anguish. I may ask other people, maybe including the defendant, but I would not be presenting any medical testimony about Cameron Fagen's mental anguish. The guy broke his jaw. He fell on his face and broke his jaw.
Does he have any disfigurement from this injury?
I'm sorry, Your Honor?
Disfigurement from this injury?
No,
Notable
Your
scar
Honor.
disfigurement?
He does not have disfigurement. He has made a relatively complete recovery. He has some pain, jaw pain, and he has headaches on an occasional basis. But he has made a relatively complete recovery from the injuries. And the injury is a very discrete physical injury.
Do you plan, Counsel, do you plan to have the jury verdicts include damages for mental injuries?
I do, Your Honor. I intend for the jury to fill out a part of the form that says mental anguish or pain and suffering is much more likely to be in this physical injury case. But this question arises in lots of cases that are non-physical injury cases. In virtually every civil rights case that I bring, the defendants want the plaintiff's mental health records. In many cases, we're happy to give them because we are going to bring a psychotherapist. We are going to bring an expert. We do want to testify about it.
Yeah, but we don't have to answer the question in those other cases. I mean, we're concerned about a physical injury with physical pain and suffering. Those other cases, I think you'll agree the rules may or may not be different because there's no physical injury. And we've treated physical injury and mental suffering different in this state.
Your Honor, that is correct. But I hope the court takes the opportunity to give this case, to give us some rules with respect to the discovery of mental health records in all cases, whether they involve physical injury or not.
I don't know if that's our function, Ms. Conlin.
Well, I understand the court's hesitancy, Your Honor, but if the court deals with this case in the way that I hope that it will, there will be rules that will be applicable to all cases. Here is what I think the court should do. There are three lines of cases, I think. One is the very narrow issue. The Northern District of California and the Colorado cases say no balancing test. It's really hard to waive your physician-patient privilege for mental health records in Colorado. There is the very broad approach taken in the Flowers case and some others, in which the court basically says, you filed a lawsuit, give them all your records, the end. You know, that's the very broad approach. And some courts say that the garden variety, or what I prefer to say is the generic pleading of mental health or mental damages or garden variety pleading does not waive the physician-patient privilege for mental health records. The only time that I have found that the court has dealt with this even tangentially is the PEXA case. And in that case, it was an automobile accident, as I recall, and the plaintiff had had the diagnosis of cancer 2 years before, and then a different kind of cancer 2 years after. And there was a discussion of the admissibility of the evidence of other physical problems. And Justice Turner's writing for the court held that those problems were admissible on the issue of life expectancy, but there was absolutely no discussion that I can find of the waiver issue at all.
Counsel, under the rule that you propose or are advancing, what would you set as the threshold for getting the medical records? I mean, are you talking about if there's going to be evidence that you're calling a psychiatric expert, does that trigger it, or what do you see as triggering it?
Here's what I think, Your Honor. If the plaintiff calls a psychiatrist, psychologist, social worker, then the privilege is waived, because it would not be fair not to let the defendant do the same thing. If the plaintiff wants to introduce into evidence the records of mental health treatment, that waives the privilege. But absent that, and absent any testimony from a mental health expert, then the privilege is not waived.
Well, Ms. Conlin, isn't that contrary, though, to the operative statute here? And that the statute says that if the plaintiff's medical condition is a factor of a claim, then the records are discovered.
The issue, Your Honor, is do you make mental health a factor of the claim by pleading generic damage, mental damage? And the answer that most courts, the vast majority of courts have given is no, you do not.
Well, can you address, maybe it's the claim in the amicus brief, it says that anytime someone brings a claim, you have to have of injury, you need to have a baseline from which to work from, or you can't properly assess the damages. And they use the example of if someone brings an injury or a claim for a knee injury, and they've had some high school knee injury prior to that time, you have to have that knowledge so you can set the baseline to go forward. How does that example differ from your case?
There are two ways in which that example is not relevant at all to this court's decision on mental health records. One is the amicus brief makes a critical error in the very first sentence by suggesting that it is the plaintiff's claim and the defendant's defense. That is not what this court has held. In the Chung case, the court held very directly that it is the plaintiff's claim. It's the patient, whether it be the plaintiff or the defendant. It's the patient's claim or the patient's defense that is at issue. Not you, the other party cannot bring in, cannot make the patient waive the privilege. The patient has to take some affirmative step to waive the privilege. The question before the court is, do you take that affirmative step by urging emotional distress, mental anguish, mental disability claims? We think the answer to that question is no. If all you are urging is the kind of damages that anybody would get from being wrapped up and beat with a stick, then that does not waive the psychotherapist patient privilege. That's our argument.
Ms. Conlin, I'm hearing maybe two different standards. One is the one you just mentioned, that is, if the only damages claimed are sort of the damages that a reasonable person, an average member of our society, would suffer from the event, if those are the only emotional distress damages, there's no waiver. The other standard I just heard you say is if the plaintiff is not putting on testimony of a professional or introducing records of mental health treatment, then the privilege isn't waived. Aren't those two different things?
I don't think so, Your Honor. What I was addressing was the question of how you tell if the plaintiff has waived the privilege. And the way you would tell is if there was evidence from a professional, either by records or by testimony. That's what I was trying to address.
Let me give you a hypothetical. I know it's not the facts of this case. We're talking about old treatment a number of years back. But suppose the plaintiff went into court and said, as a result of this incident, I'm suffering from nightmares. I can't sleep. I'm just under tremendous difficulty sleeping. I have bad dreams all the time, and the plaintiff also had seen a mental health professional just during the year prior to the incident. It would be your view that would not, by making those statements, say in deposition, the plaintiff would not be waiving the privilege and the defendant would not be entitled to look at those records and see if the plaintiff had been treated for nightmares before. Is that your position?
It is, Your Honor. And the Flowers case, which is one of the very few cases cited in the amicus brief, is very instructive in that regard, because in that case, the court held there was a waiver. And the court held there was a waiver because the plaintiff testified in his deposition that he had not left his house for 3 years that he was afraid to leave his house, and he also testified to all the symptoms of post-traumatic stress disorder. That is a diagnosis. That is a mental health diagnosis. If there is a mental health diagnosis, then again, if there is some diagnosis of post-traumatic stress disorder, agoraphobia, or anything like that, then you've waived the privilege. We've done no such thing here, but nightmares don't waive the privilege. Feeling bad doesn't waive the privilege. Feeling scared doesn't waive the privilege. Only a diagnosable mental health issue would waive the privilege, in my opinion.
Counsel, it seems to me that if we adopted a garden variety exception, it could be different. This case might be easy, the next case might be a little closer to the line, and et cetera. Isn't an easy to apply bright line rule is if you're asking the jury to award money for a mental injury, you've opened the door to discovery into the records.
Well, that's the argument of the defendant, Your Honor, that if you file a lawsuit, all bets are off. But there is a constitutional issue at stake here. The right to privacy is a constitutional issue that is at stake. You cannot just require an innocent plaintiff, a person sitting at a stoplight who gets run into, you can't require that person to disgorge their marital counseling records. That's just not fair. That is basically a part of the issue that we have here. What is fair and what is not fair?
But couldn't we protect the privacy of those records with a protective order so nobody sees them, and then a motion in limine if they're irrelevant that the jury doesn't see them?
No, Your Honor, because somebody would see them. The judge would see them, the defense lawyer would see them, the defendant might see them. That's not sufficient to protect the right to privacy. Jaffe deals with that as well. So, thank you.
Thank you as well, Ms. Conlin. Mr. Carmoney.
May it please the court. There are going to be some issues that the parties agree. We certainly agree, for example, that there is a right to privacy that extends to medical records and that would include the subcategory of mental health records. That follows the physician-patient privilege. In Iowa, however, there is an actual codified provision in the code that establishes that privilege, and that statutory provision lays out a specific exception for cases in which the condition of the plaintiff has been made an element of the case or a factor of the claim.
Can that statute overrule someone's constitutional rights?
Well, what we know, Your Honor, is that there is no. I'd say the answer to that is no. However, it is a starting point for the discussion, and at some point the court would have to consider what the reason was for the legislation. There is a constitutional issue that's invoked in the case, but the issue being raised, I think, by the other side is that there's a right to privacy. We know that the right to privacy is not absolute. There are times that right can be waived by a party. That's been addressed in a number of cases, including the McAllister case here in Iowa.
But as I understand your argument down below, which is a little different than what the amicus are talking about up here, you told the court that if she would drop her mental disability label and just went mental pain and suffering, you'd have no problems of not getting the records. That's on page 115 of the appendix. I mean, and then when you look at the transcript of what Ms. Conlin was going to prove, it was basically mental pain and suffering. It was not mental disability. And there is a difference between the two, and I agree with you on that. Is that still your position up here as you had down and below in the lower court?
Well, I think the other attorney at my office that handled that hearing at the lower court indicated a hypothetical that maybe if this particular plaintiff had actually pled a case where he stated something that would be equivalent to garden variety emotional distress, maybe that would be a different scenario. But we did, I think, point out clearly, both below and in our briefing here, that this case actually is quite different. What they've pled here in this case is disability.
Well, let's take Ms. Conlin for her word at the hearing. She's only going to ask for humiliation. I think she lists 4 things, you know. She's not putting on an expert, and the way I read it, it's what the jury instruction says mental anguish is. It doesn't go beyond that. What would be your position if that were the sole case?
Well, we'd be back to the causation question for starters. Even if we're talking about only garden variety emotional distress, the kind of thing that she says would be the normal, predictable symptoms that would come from a physical injury, the kind of thing that a normal, well-adjusted person might experience from that, it still doesn't, we would still need the opportunity to evaluate whether or not there was some other factor in that person's life that predated the incident that could have actually created those.
Does the eggshell theory have any role in this analysis? You take your plaintiff as you find them?
Well, I guess, Your Honor, I looked at more the aggravation side of things. We could have a situation where someone has an already existing emotional problem or mental health problem that might be exacerbated or aggravated by an incident that occurs involving physical injury, but wouldn't a defendant still have the right, in order to get some sort of a fair evaluation of what existed before the incident and what was actually caused by the incident? That would be one of our key concerns in the bigger picture of this is there's that whole question about causation. Secondly, there's that whole issue of where is that baseline? It would seem that a defendant should have the opportunity to know what he's dealing with. If the whole point of this is there should be some generic level of emotional injury that would be recoverable even without any sort of evidentiary beyond just the plaintiff's own testimony, how do we know where that position started? How do we know whether that person was truly well-adjusted in the first place?
Would you agree with me that every circuit court in this country and most of the Supreme Courts of the states will not allow you to get those records if it's the mental anguish? Take out the word disability, just plain mental anguish.
I think the Eighth Circuit is one exception to that, Your Honor.
Well, the Eighth Circuit, there was medical testimony on one side. I'm saying without any medical testimony from the plaintiff, and you're only asking for garden variety, is the majority opinion throughout the country is you don't get the records.
Well, there are 2 schools of thought on that, and they're pretty well laid out in Stephanie Thomas's law review note that is pretty interesting on that.
But I mean, if the majority position, and maybe I'm wrong, maybe you're right, I read stuff wrong. If the majority position is that you don't get it, why should Iowa give it to them when there's garden variety, disability is out of there, and there's no expert testimony on behalf of the plaintiff to show that it's nothing more than what a normal person would suffer from being assaulted?
I don't know whether those federal circuits address the constitutional issue in those cases, and I can't chronologize the federal case law on that. I do know that the federal case law is based on a developing common law that does vary from one circuit to another. Here in Iowa, there is the benefit of the legislature's approach through its statutory language in 622.10.
We have to go through 3 analyses on the statute. Number 1, we have to figure out what the statute means. Number 2, we have to weigh that against the constitutional right of the party. And on top of that, you have to go to the discovery rules because it has to be reasonably calculated to lead to discoverable material. Admissible evidence, I'm sorry. And if you look at our Cashin case, and then the legislature overruled it where there is a balancing test in the criminal area, you know, we were very careful not to allow anybody to look at those records in the beginning, and then the legislature changed it, even made it less person look at those records. So at the very least, I mean, how can you ask us, say you're entitled to the records, don't you think there has to be some safeguards where you have to make that initial showing that there's something there instead of going on a fishing expedition? And that's what we said the constitutional issue is. And then once you get by that initial the court believes it's not a fishing expedition, you have some reason for those records to be there, don't you think we have to give the same safeguard that we give a person in a victim or a witness in a criminal case to this plaintiff? So the records just aren't out there.
Your Honor, I don't know that I would agree that the safeguards that are in place in a criminal scenario would also apply in a case of a civil lawsuit where
Maybe
the
not,
plaintiff...
need more protection in a civil lawsuit, don't you think?
Well, a civil plaintiff has the decision to make as to whether they choose to place this at issue in the claim or not. If they do, there are some protections that are in place and safeguards that our system provides. From the very beginning, they have the opportunity to ask for protective order, potentially ask for in-camera review if there is something in there that is especially sensitive. I was thinking about the scenario where it's not just a bunch of college kids messing around, but it's a situation where someone has been victimized by a dangerous perpetrator and there's information that could create additional danger. There might be a reason there for a district judge to get involved and review those records.
Let me ask this question. It's a factual one, but do you know whether there are any records within 2 years of the incident, for example?
We don't, Your Honor. We have to simply take plaintiff's word for it, and that's one of the problems with allowing the new garden variety emotional distress exception that the appellant side is pressing here.
Doesn't defendant have the same problem in a criminal case where he has a right to a fair trial, that you cannot get those records unless you have a reasonable belief they're there, or, you know, it's almost like our discovery standard, which would be applicable here. I mean, you just can't go on a fishing expedition to start sending records out to get things. And that's a problem in a criminal case. The legislature set that standard. And why should you go on a fishing expedition in a civil case when you don't balance the right of fair trial of the defendant versus the privacy? Because this court has said there is no balancing. So why do you get to go on a fishing expedition?
Well, candidly, Your Honor, I don't know how a defendant in a civil lawsuit is going to be able to gather the information needed to be able to put together some of its defenses without being able to gather those records. And the legislature saw fit to create that exception for the patient litigant scenario where a defendant has been hauled into court and is accused of something.
Doesn't the discovery standard kick in too? I mean, it's just not a blanket fishing thing. You have to show that what you're doing is reasonably calculated to lead to admissible evidence. And don't you have to meet that standard, and you can't go on fishing? And that would be consistent with the criminal area where it's even more important for a defendant to get those records.
Well, the rule is that a defendant has a right, just as much as any plaintiff does, to obtain information that is reasonably relevant to the issues that are in the case. The plaintiff has the choice.
Counsel, if I could just interrupt for a second. You suggested that the only way you can sort of probe the veracity of the plaintiff's version of his history and his prior mental health is to get the records. But aren't there some other ways you could do that short of getting the records? To start with, at least, I mean, you can investigate how he gets along with folks. You can investigate his employment history. Has he had problems? Is he erratic? You can do all of that without getting his medical records, right?
Well, the two obvious ways to gather that information would be to serve written discovery on his attorney and receive written answers to discovery requests, and the other option would be to take the plaintiff's deposition and ask those questions of the plaintiff.
Or to do your own investigation, to inquire of his former employers, talk to his circle of friends at school, that sort of thing. There are some things you could do short of getting the records, right?
Well, potentially. I don't know about gathering employment records. Again, without some sort of a waiver supplied by the plaintiff, I don't know that it would be practical to expect that you're going to receive employment records on a particular person.
Wouldn't the starting point be the records of physical, and that's what these courts talk about, the physical injury records, where every time the patient goes in and they ask him, how you feeling, what's going on, this and that, that would give you a starting point. I mean, if you came in and said, I'm really depressed and I don't feel good and it's more than just from this injury, you may have something to go on. When you look at a person's past medical history, a doctor's office is full of past medical history about what they did and they didn't, and you get that when you get the physical injuries. I mean, there's other ways to start to give the court some assurance that you're not going on a fishing expedition.
Well, Your Honor, in my experience, what happens is you wind up getting back only medical records that relate to physical treatment, and unless that box is checked on the waiver that indicates that mental health records are permitted to be disclosed, I'm going to wind up with some redacted version of the records that's not going to include that information about a person's unhappiness, upset, anxiety, depression, any of those kinds of things. I just recently tried a case where the plaintiff did not place her mental distress at issue in the case, and so there was not a box checked on that waiver form for mental health records. And what I got back were records that someone at the clerical level had literally gone through with a black marker and attempted to redact out everything that involved mental health problems, emotional reactions, depression and anxiety and so forth. They're often incomplete in their redaction, but that's typically what we get. So that's part of the problem. The plaintiff in this particular case seems to be concerned about the idea that there is some abuse that's being committed, and the reality is that's not really what occurs. There's not humiliation and bludgeoning that goes on in a case like this. I mean, the most counterproductive thing that I could do as a defense attorney would be to step into the courtroom and attempt to humiliate or embarrass a plaintiff. But there were those suggestions made in the appellant's briefing. It is a case where
doesn't it chill a person's, to seek mental health if they know that their mental health records could be available? If 10 years from now they have an automobile accident, you can start fishing. I mean, that's the whole basis of the privilege, and we discussed that in Cashin and the cases subsequent to Cashin, dealing with that issue.
Well, I think there have to be reasonable limits on what information can be fished from the pond, so to speak. But at the same time, in an injury case where the plaintiff has made the mental state an issue in the case, when they place it at issue in the case, the defendant should have the opportunity to seek out information relevant to that point. And
I think you need the records, the 4th to 6th grade anger issue records?
I mean, in an individual case, maybe not. In this particular case, we've got a young man that was 18 years old at the time. I mean, looking back on this, we probably could have asked for the last 5 years and found out everything that we would need to know that would have to do with causation, that would have to do with establishing that baseline. If the plaintiff side had come to us or come to the court and requested a limiting order that would allow us only a certain amount of time that would be more reasonably related to the actual issues in a particular case, I don't know that would have been a problem at all. But what we have here is just an absolute blunt refusal on the plaintiff's side to comply with our request.
The defendant lived in the dorm with these kids, and you could talk to these kids if this guy was anxious, nervous, wacko, whatever you want to call him, before you start going fishing in his records. I mean, you didn't even do that in this case. There's no showing of that here.
Well, it's an interesting question what was really going on in this particular plaintiff's mind. There were some indications in his own deposition that he was feeling, he talked about his feelings at some points during his own deposition.
The problem is the deposition's not a record here. And, we checked the record. It's not made a part of this record here. So I don't think we can consider that.
But isn't our standard of review abuse of discretion? And in this case, the district court looked at the position of both parties, had a hearing. Can't we trust our district court judges to draw the line in the right place on discretionary rulings?
Well, and Your Honor, that is the position that we take in this case. We believe this is really, at the end of the day, a relatively routine discovery matter that the district court evaluated. District court held a hearing, considered the arguments of counsel, and considered briefs that were submitted, and issued a pretty good, thorough ruling on the issue, and considered exactly the questions that were raised. Because of the fact that the plaintiffs pled this case the way they did, as severe mental pain, mental disability, by very definition, it takes it outside this garden variety situation that they are kind of coming up with now. The issue before the district court was really pretty simple and discreet and was addressed properly by the court.
Thank you, Counsel.
Thank you.
Ms. Conlin.
Justice Waterman, no, not abuse of discretion. This is a constitutional issue. This is an issue of whether or not you can invade a constitutional right to the privacy of records in mental health records. Mental health records
And we've recognized there's a constitutional protection for mental health records, but it's not absolute. We said in the AM case this fall, and citing our earlier cases, but any constitutional right can be waived. I mean, you can waive your right to counsel, you waive your right to a jury. The question here is, did she waive a right by alleging and now ultimately asking the jury to award him money for a mental injury? And can't the plaintiff control that by just seeking only physical injuries rather than mental?
I think the answer to both of the questions that you posed is, in fact, yes. The plaintiff does have the power to narrow the issues, and the issue of causation can't come up in these cases because you are only asking for the mental damages that are caused by, would be caused to anybody by whatever happened. The defendants seem to be saying that something might be in those old records, those 10, 12, 14-year ago records, and we want to look at them. We want to turn every page. We want to read every word. Maybe we'll find a sentence. Maybe we'll find a phrase. Maybe there's something there that we can use to embarrass or humiliate further the plaintiff in this case. That is what mental health records sometimes are used for, and I know that for sure.
Is the solution to have the district court judge do an in-camera review first?
No, Your Honor, I don't think so for the reasons that I said before. This is a constitutional right. This is the right not to have the judge look at those old records. If all I'm asking for on behalf of my client is just let me have the damages that anybody would feel if they fell on their face and broke their jaw. And that's what I'm asking for.
Well,
Let me ask this
you
question.
do stated, and it's been stated several times, that this is a garden variety.
I really like generic better, Your Honor.
Yeah, well, whatever that type of label, but that doesn't prevent you from asking the jury for $1 million or $10 million or whatever. And so there's a constitutional right on the other side here too, is there not? A due process right to defend against a claim, and a claim that could be a substantial part of the lawsuit.
Well, Your Honor, in this case, we have a doctor, a medical doctor that you don't like and that you don't trust can set your broken arm or your broken leg and do a fine job. That is not true of a mental health professional. You have to like the person enough to tell them your secrets. And that's the purpose. You know, your dreams, all your secrets are what you're confiding in this mental health professional. And those records, as recognized in Jaffe, as recognized by this court in Astronfelder, as recognized by you, Your Honor, in your dissent in the Cashin case, those records are different. Those records deserve the constitutional protection that we are urging that they should have. And it really puts the plaintiff, gives the plaintiff kind of a Hobson's choice. Shall I bring a lawsuit or shall I not?
Let me ask you, if I may, I'm struggling with something, and I'd ask your help. It's one thing to put on evidence of the event that happened and say we want to collect mental anguish damages. And the argument is anybody that gets subjected to the treatment would suffer anguish. And that seems fair enough. But let me change it, the hypothetical just a little bit. Supposing your evidence is, well, we had this event, and since the event, I've had headaches. It's a somewhat different situation. Now we have not just simply the anguish that logically arises from the event, but now we have at least a claim of ongoing headaches. Now, at that stage, would the defense be entitled to get medical records related to headaches?
I don't think so, Your Honor, because headaches can come from lots of different causes, including the physical injury. And I think they get the records of the physical injury.
Well, let me put it, okay, but if the testimony was just as I described, it's a hypothetical, I know, the only additional element is the headaches or the sleepless nights, let's just say. And my discovery was focused right on that, and I said, well, I want records related to sleepless nights for the 2 years prior to the accident.
Not the 10 years?
Not the 10 years, obviously. I mean, frankly, some of this goes way back so far, it's hard to, I mean, I'm not very sympathetic, frankly, with the 4th to 6th grade stuff. But if someone was claiming to recover for sleepless nights, and the request was any medical records related to sleepless nights within 2 years, let's just say, is it your position you couldn't get any records?
No, Your Honor, you can get, I think under those circumstances, you can get the physical records, but I'm not going to give you voluntarily unless you make me any mental health records because
What if
I
they
claim
relate to
sleepless
headaches?
nights.
What if, I mean, let's just suppose that there's some, let's say there are mental health records related to sleeplessness 2 weeks before the incident happened. And then at trial, you're wanting to recover for sleepless nights. I mean, the defense might want to say, well, that wasn't really caused by getting rolled up because you went to the therapist. Is there any way for the defense to get at that?
I don't know, Your Honor. That is, under those circumstances, I probably would like to have the records because it would make sense to me to do so. But that's not the usual case.
I mean, it depends what your evidence shows is what I'm
Yes.
kind of suggesting. I mean, I understand there's certain events, and we can all think of some of these outrageous torts where someone calls and says, your husband just died. And, to collect emotional distress damages on something like that, we all going to nod and say, oh my golly, yes. And I think you're making kind of a similar claim here. And I understand that there's certain kinds of damages that arise from the occurrence itself. But as soon as you start going beyond that and say, well, he used to duck hunt, he doesn't duck hunt anymore, or obviously I don't know the particular facts in your case here, and we haven't developed them, but when you go beyond what has logically arises, then we get in a different area, do we not?
Well, I think, Your Honor, I know that the court has asked for bright line rules, and I think there are some. And one of them would be, one of the reasons I did not plead severe, tortious infliction of severe emotional distress is to avoid triggering any sort of discovery of mental health records in a physical injury case. So if there is no plea of a separate tort involving mental health damages, that would be one bright line. If there is no use of the records, that would be another bright line.
Let me ask you this. Supposing this case went forward and you were barred from introducing any evidence related to anguish other than the occurrence itself.
Other than the plaintiff himself?
Yeah, other than actually the occurrence. I mean, you say this occurrence happened, blah, blah, blah.
But why would you do that? Because, in fact, there were things that happened. I mean, this was humiliating.
Sure, and I guess I'm not quite that narrow. But what I am suggesting is you may not be able to allow about sleepless nights or the claim of headaches and subsequent mental health conditions. I mean, maybe you can't get into that because you don't want to offer the discovery. I'm not sure. I'm just asking.
Well, and I'm not sure either, Your Honor, but I think there are some common sense things that we could agree on. But I'm trying to help the court to formulate a way of distinguishing between a tort that involves emotional distress like severe infliction and the generic type of claim that I have made here. And so I have suggested that no separate tort, no medical evidence, including records or testimony, no specific mental diagnosis such as post-traumatic stress disorder or depression, And the plaintiffs will not claim that the defendant's conduct in any way exacerbated a pre-existing illness. Those are 5 things that I think would be helpful to the bar in general in trying to work through these somewhat difficult problems. And I think that were the court to do that, it would be helpful to the bar, and certainly it would not. We trust juries to do a lot of things. Certainly we can trust juries to establish whether or not the individual is a reasonable person who has suffered reasonable generic type of mental distress. Thank you.
Thank you as well, Ms. Conlin. The case is submitted, and we'll now hear the arguments in the Blessman matter.